shit.
Get over here now.
No, you get over here then. He wants to say get over here like I'm a dog.
I will get over here.
Yeah, exactly.
What is going on?
Yeah, exactly. Get away from me. Get away from me. Get away from me. Get away from me. Stop. Stop. Help. Help. Help.
Give me your hands. Give me your hands now.
Good morning. My name is Jessica Saxon. I'm a civil rights advocate and litigator from Washington, D.C. I'm here to provide a public notice. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution for the United States is the overarching requirements that every state must follow. I trust that everyone here would agree with that. States cannot enact their own alternative legislation and substitute it for the guarantees of the Constitution. That would mean that your state laws are in fact more powerful than the Constitution, and that is unlawful. Clause 1 of Amendment 5 states that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. However, the state of Texas, unfortunately, has enacted its own alternative legislation that substitutes the prosecuting attorneys, police officers, and judges to charge by way of information as opposed to indictment. That is unconstitutional. An emolument violation is when you pay a public official to commit a crime. There are two areas of the Constitution that reinforces this. The first is Article 1, Section 10, where it states that no state shall create any law that shall impair the obligation of contract. So a contract, police officers, prosecutors, your judges, they are all under a contract to perform based on the oath or affirmation that they took to support and defend the Constitution. The contract perimeters that are defined within the Constitution of the United States are in fact found within those oaths. So when a state enacts its own law and directs their agents to disobey the law, the Constitution of the United States, that is a violation of Article 1, Section 10. The 14th Amendment is the other place that you find this reinforcement, and that's where it says that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. Privileges and immunities of the United States citizens are at a minimum those that are guaranteed in the Bill of Rights and the first 10 amendments. The state of Texas, again, has enacted a law in its inferior constitution that is permitting public officials and law enforcement officers, whom you all pay, to violate that constitution. As a result, there's an inordinate amount of people currently imprisoned here in the state of Texas, illegally and unconstitutionally. Mr. Tanawa Downing is preparing to litigate this issue at the United States Supreme Court on behalf of roughly 700,000 people currently incarcerated here in America unconstitutionally. I'm here today to simply provide notice that you cannot continue to pay public officials to commit a crime. Criminal sanctions can come from that. We must make officials aware that paying public officials to break the law is an emolument violation, it is illegal, it is unconstitutional, and I'm asking you, honorable individuals, to please take a look at Clause 1, Amendment 5. Confirm what I'm saying to be true, and direct your public officials to act in a lawful, constitutional manner that is consistent with the obligations that are codified in the Constitution of the United States. Thank you so much.
Thank you, Ms. Saxton. And now Mr. Downing. And again, he's speaking on number 8, which is our recommended budget. And I guess that's what where you're getting to is paying the officers.
Yes, sir.
Okay.
Yes, sir.
Okay.
Yeah. So I'm the civil rights litigator that Ms. Saxon was just referring to. Thank you guys so much for allowing us to speak. And yeah, just as you had said, the reason why I want to step up here is I want to provide just a little bit of clarification so you guys can understand, what it was that we just said. When the state creates a law and it's inferior constitution that is in conflict with the Constitution of the United States, then that would be an unconstitutional law. So then when the law enforcement, your public officials, when they choose to rely upon that inferior state statute to go out and perform their work, well, that is an unconstitutional act. In fact, it's a crime. It's Title 18, subsection 242. It's called deprivation of rights under color of law. What that law states is it says that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits that crime. Now, we're not trying to get anybody into trouble. That's not what we're trying to do. We're trying to raise awareness on an issue that we really need to get addressed because, again, today there's more than 700,000 people that are currently in prison here in America that didn't receive an indictment by a grand jury, despite the fact that that is codified within the Constitution of the United States. Now, I know that you guys are probably going to go to the city attorney or the county attorney and ask them if this is true when we're done. And the county attorney is going to say to you, well, probably not. And they're going to point to a specific case from the United States Supreme Court from 1884 called Hurtado versus California. And before you guys choose to rely upon that as the foundation, I want to remind you guys that the Constitution of the United States of America is the foundation, not a judge-made ruling. Supreme Court of the United States has no authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution. That's because, one, judges cannot legislate. That's codified in Article 1, Clause 1, where it says that all legislative power is vested in the Congress of the United States. Judges have no authority to be able to create law. But the other part is that the amendment to the Constitution must be done in accordance with the special amending procedure, meaning that it must be done by an authentic act of the people, and any other way would be an unconstitutional act. So this is a very, very big deal, and we want to get this addressed. And again, the reasons why we're here right now is because if the Sheriff's Department budget that you guys are preparing, if those sheriffs are going out and performing and executing a warrant, but that warrant is based upon a judge's order that's based upon a prosecutor's reliance upon an inferior state statute that's depriving a person of right guaranteed by the Constitution, that sheriff is unfortunately committing the same crime and is a member of a conspiracy to deprive rights, Title 18, subsection 241. Then when that sheriff arrests an individual and puts them into a jail, and that jail then houses them after performing an unconstitutional arrest, and that jail is also acting unconstitutionally. So we're asking you guys to please step up, discharge the duties of your office, fulfill the obligations and promises that you made to the people of the state of Texas, and let's protect, defend, and preserve the Constitution for the United States of America. I have a notice that I'd like to place on the record so that you guys can review it. Thank you guys so much.